Homework. Or perhaps this existed already.
No, it didn't exist already, my lord. And in particular, my junior team and Ms. Liu, I think, can take primary credit for it. It was in response to your lordship's request for a sort of a nutshell guide. So,
did I prevent the case being called on by?
Oh,
it's a bit. Well, that's not what I'm worried about.
Right.
No. Yes, carry on.
Can I consider it called on?
Yes, you can.
My lord, 3 things have landed on your desk from our side. The first you've already spotted as being a table, which I shall come to in the course of ground 2.
Yeah.
But is you'll be able to see cross-references the judgment to Ms. Hanley's statement and addresses that policy by policy, as it were, with some commentary. And it's not an agreed document, it's a document that we produce both in response to Mr. Payne's submissions that we...
No, that's fine, I understand not agreed, but obviously Mr. Payne saw it once it was done.
Yes, he's seen it this morning.
Yeah.
Well, sorry, I've just seen it.
Yes, this morning at court.
Right. And then I'm sure a lot of work was done, and I can't say till we're ready that it's very good, but it must have been. It looks very well presented, and thank you to those.
We hope it will be of assistance. What it includes at the end, and I don't want to preempt, but is what we have worked out to be the timing in relation to the statutory guidance that was consulted on, according to Ms. Hanley's statement, as described in Ms. Hanley's statement, in that passage from about paragraphs 24 to 27 of her statement.
Well, that'll be helpful as well.
There was some discussion. There's an authority of BAA, which we'd referred to in our submissions in relation to the academic point. There's only a tiny bit of it that's of any relevance.
I had a quick look on my screen. I couldn't find anything.
No.
I assumed there was something, and you're going to tell us what it is.
I'll come to it in the course of the academic point.
Okay,
it's paragraphs 16 to 18, which have a slight impact on the academic point. And the third thing is an example of a DSO. My Lord, the Vice President
thank you.
asked to see one. That is an obviously relevant one.
That's fine. So, yes.
So
okay.
But
it's presented, it's produced not because of its content, but
exactly.
Okay, thank you.
My Lord's
and then there's my Lord's judgment about which he was so self-deprecating.
Yes, that emanated from Mr. Payne. I'm sure if we'd known we were going to have Lord Justice Newey on the division of this Court of Appeal, we would all have been obsequious enough to have included that. But it's a helpful and recent summary, as cited by the judge.
Yes, I see. Well, I hadn't realised that's his handout. We'll wait for him to.
Yes.
Okay, thank you.
It's so that you have the full piece.
Yep. Right, off we go.
So, my Lords, I'm hoping to finish by 12 or soon after. I'm also hoping, although my own estimates are usually no more reliable than Mr. Payne's proved to be yesterday, but not to extend much
the court's fault, so don't worry.
Beyond that. In the last half hour of the sitting day yesterday, I sought to provide an overview of the relevant statutory and non-statutory policies to provide the backdrop against which the second opinion policy fell. One point to pick up, my Lord, the Vice President raised a query as to the regularity of reviews, and I wasn't able to give a very precise answer, and those more informed said, well, there are various intervals. Just so you have it, in the supplementary bundle at page 260 is a table which shows, on that page, non-foreign national offenders, and then the page afterwards, foreign national offenders, the scheduled series of reviews.
Yep, thank you.
And at least passing note is the text immediately below that table, providing that if what's described as a significant and or material change. I'm not sure what the difference might be. In circumstances in between reviews, during the initial stages of detention, an inspector or SEO must conduct a review, and then where it's at a later stage or during later stages, then the review must be conducted by someone of the relevant grade. So the point there being that even with in between scheduled reviews, anything which constitutes a significant and or material change requires a review of itself. And this guidance was in place at the time the second opinion policy came into effect. So making clear, reading the whole piece, the requirement for a significant and or material change, which an MLR that reaches the baseline standard in our submission clearly would be.
Can I just ask, so there was it was 7 days and 1 month, but it is monthly once you've gone past the first month, even for non-foreign national offenders?
Yes.
Yeah, that's what I'd understood.
That's my understanding of this table.
Thank you.
So, my lords, I was then going to proceed in what seemed to be a logical order to the academic point. I've rejigged on the basis that time may become compressed later in the morning. And I propose now to address ground one, then ground two, and then turn to the academic point. There's a lack of logic in it, but...
no problem.
My lords, can I say at the outset, you will have seen our skeleton, no doubt read our skeleton. We adopt that. I'm not going to follow it slavishly. It sets out in what I would venture to hope is a coherent manner our argument. The bit, and we adopt it, save for the bit, obviously, which relates to the respondent's notice points. In relation to ground one, I've set the scene to an extent in relation to the statutory guidance. I want to go back to the statutory guidance in a slightly more granular exercise now to make good, as I would hope, our submission that the judge was clearly correct to find that the second opinion policy was inconsistent with the requirements of the statutory guidance, which of course is the crux of his finding in relation to this part of the case. I've already referred to and given you repeated references to the presumption against detention, paragraphs 3, 6, 1, and 13. I say 616, bullet point 1. I won't repeat those, but could I ask you to turn up the statutory guidance at page 289 to pick up some specific points which, as we submit, are of significance in evaluating the key issue of the consistency of the second opinion policy with what is set out here. So it's core bundle, page 289.
Can I just, before we do that, before you get to the presumption of against detention, the power is under the Immigration Act and the relevant law is Hardiel Singh. Everyone's agreed on that.
Yes, it goes back to Hardiel Singh. I mean, there's Lumba more recently, but it's
the Immigration Act, Hardiel Singh and Lumba, as it were. Because before you get then to the presumption against detention, in many respects, that's picking up the common law.
Yes.
Yeah.
And that, well-settled principles that the state has to justify its detention, and there's a presumption against detention.
Sorry to interrupt.
No, not at all. So paragraph 1, the first point that I highlight is the reference to the government's response in the written ministerial statement to the report by Stephen Shaw. And that is, as we submit, relevant background recited in the purpose and background. And the easiest way to take the court to that is by way of paragraphs 14 and to 16 of the judgment below, where Mr. Justice Linden refers back to a case which is in the authorities bundle. I don't need to ask you to turn it up, but a prior medical justice case where Mr. Justice Ouseley provided what's described as a very helpful account of the background to Section 59 and the statutory guidance. And then Mr. Justice Linden's summary at paragraphs 15 and 16, leading to, as he says, the enactment of Section 59 and the required statutory guidance. So that introduces the concept of particular vulnerability to harm in detention.
I thought, in fact, doesn't it go back before, Mr. Shaw? Doesn't it come from the Strasbourg case law?
Oh, the presumption against detention.
No, the concept of particular vulnerability and particular vulnerability may not matter.
Well, I'll go with
forget it.
Developed the concept is the. So I'm not suggesting.
Yes, developed.
He invented the concept.
No, right.
Yes, certainly, and I'm sure it's correct that particular vulnerability is a concept which pre-existed, but was developed.
Yeah.
As a result of the Shaw review. And the citation of the ministerial statement at paragraph 16 is, in our submission, of significance in understanding the purpose and background to the statutory guidance. Then within paragraph 1, one can see just below the middle of that paragraph the sentence which starts, the intention is that the guidance, well, it's probably exactly halfway, the intention is that the guidance will, in conjunction with other reforms referred to in the government's response, lead, these are the words that I seek to emphasise, lead to a reduction in the number of vulnerable people detained and a reduction in the duration of detention before removal. And then going on to refer to the holistic approach, which I think Mr. Payne had sought to emphasise. And then, of course, the balance between ensuring that vulnerable people are not detained inappropriately on the one hand and the maintenance of legitimate immigration control on the other. So a stated purpose to reduce the number of vulnerable people detained and reduce the duration of detention before removal. Paragraph 3 I've already referred to in relation to the clear presumption. The word clear seems to have been added and may be of significance. And then paragraph 4, first sentence makes clear that it will apply in all cases in which an individual is being considered for immigration detention, and then goes on to require the assessment. An assessment will be made of whether the individual is at risk, and if so, the level of risk, based on the available evidence. And we've seen how that works in practice in relation to the caseworker guidance, non-statutory guidance. Only when they do so will the individual be detained.
But the complaint, as I understand it, is not really in relation to those who are about to be detained, because obviously adding a period of time before they are detained is not going to cause any problems. It's only for those who are in detention.
Yes. And that's picked up in the next paragraph, in the last sentence of the next paragraph. As in the opening sentence of paragraph 5, we see a sentence which we say gives the lie to Mr. Payne's suggestion that this is not about processes, it's about establishing criteria. It's expressly about processes. The processes set out in this guidance apply to all cases in which consideration is being given to detaining a potentially vulnerable individual. And then, as my Lord Justice Dingemans says, similarly, it applies to those already in detention, although there are some differences in the way these cases are managed.
But just really building on what my Lord just said, typically, though not necessarily, the particular issue in this case, deciding what you do when you get an MLR, will arise only after there has been detention.
Yes, and it's almost axiomatic, because the MLR only falls to be considered for someone who is in detention.
Well, I don't want to quibble with you, just make sure I've understood it. I thought we'd read yes, or I read yes to Mr. Payne. You could have a situation that will not be typical, where an MLR exists prior to detention.
But that will fall outside the second opinion policy.
Oh, I see. Thank you.
So certainly there could be pre-existing MLRs, but for the purposes of the second opinion policy, it's an MLR that's contemporaneous with the relevant period of detention.
And that was the 298.
Yes. So then paragraph 6, the main principles underpinning the guidance. The first bullet point picks up paragraph 1 and is an echo of paragraph 1. Fewer people with a confirmed vulnerability detained. Shortest period necessary. And one can read through those, but on the penultimate one on that page, assessment of risk is based on the evidence available, and then the range is set out. And the evidence available dictates the level of evidence-based risk into which any given individual will fall, and we now understand how that works by reference to the caseworker guidance. And then the final one on that page, not immediately relevant to the second opinion situation, but relevant to understanding the purpose and intention of this guidance. Where professional evidence is not immediately available, but where observations from Home Office officials lead to a belief that individuals at a higher level of risk than simple self-declaration can be allocated to a higher risk category based on the basis of that observational evidence. So then 7 really echoes what we know about the levels of risk from the caseworker guidance. 8 picks up again the repeated reference to decisions being made on the basis of the available evidence. The Home Office will reach a view on whether a particular individual should be regarded at risk, and then the presumption that the individual will not be detained. And then the last point that I seek to highlight from the statutory guidance as shedding light on its requirements. Paragraph 9, once an individual has been identified as being at risk, consideration given to the level of evidence and the weight that should be afforded. no scope for, on the face of it, for delaying that process of identification.
I mean, at the risk of taking out of your course, but while you're on paragraph 9, the first one is self-declaration, accorded limited weight, even if the issues raised cannot be readily confirmed. I mean, that suggests there might be a possibility of seeking confirmation.
Yes.
How does that work?
Well, I would envisage, without particular experience of this, that there would be the ability to make inquiries which would tend to support or cast doubt on that self-declaration.
And can those inquiries take more than a de minimis period?
As initiated by the Home Office, I'm sure they could, yes.
Do you have to release the person in the meantime, or generally make a decision on the basis of the self-declaration without waiting for the result of the inquiry?
Yes, you have to make a decision, but the decision may very well be to continue detention because it's only level 1 self-declaration. So you can't avoid making a decision, but it's just a decision that's likely not to lead to release because it's only level 1.
Yeah.
Can I, just on the same theme, on level 3, where you do get in the medical report, but where, talking particularly about foreign national offenders, where in for offences of dishonesty and all the rest of it, and the prison officers know that he gave an account of asylum to a tribunal which was manifestly disbelieved. There, on the fact it's level 3, might suggest immediate release. But what happens if the Home Office want to go back and get the transcript to confirm that, in fact, what the doctor has perfectly understandably accepted as true is not?
Well, that's provided for in the ability to take into account and reconsider in the light of tribunal rulings.
Yes, but my Lord's question is, what if you have reason to believe there is a tribunal ruling, but you haven't yet got hold of it, and it takes you some days, as it easily might, to get it?
Well, slightly without sidestepping the point, but it's in practice, it's hard to see why it would take a number of days to obtain a tribunal.
I'm afraid transcript delays are notorious. I mean, in the system. It shouldn't be, I entirely agree, but I'm afraid they do take time.
I think FTT reports are not available online routinely, whereas upper tribunal ones are. So you would have to get a transcript or go.
Well, if you've got a genuine doubt, if you believe that there is a tribunal ruling which casts doubt on what is in your level 3, then that falls within that feeds into the process of whether it's in fact level 3 at all.
Well, it is level 3 simply because just the way it's dealt with, but you might be saying that immigration review takes account of what you're informed from the prison officers, as it were.
Yes.
Yeah.
So, I mean, what you're told by the prison officers may impact at either stage, at the vulnerability and risk stage, or the immigration control stage. And can, of course, be taken into account pending confirmation by reference to the actual transcript. You're entitled to take into account information that if you're told he's been entirely disbelieved, then that can feed into the decision. So, my lords, you've seen the effect of the second opinion policy, which is to put on hold substantive consideration of a medico-legal report that clears the baseline threshold, pending the further inquiries. And our submission is that that is contrary to the clear purpose and terms of the statutory guidance in the following respects. Firstly, it frustrates the statutory presumption against detention. Secondly, it prevents a caseworker from
Sorry, give me 1 second.
Sorry.
Sorry, one, frustrates the statutory purpose, the purpose that it got.
The statutory presumption against detention.
Well, not just statutory.
Well, the presumption against detention, which is reiterated in the statutory guidance as a clear presumption. Second, it prevents the caseworker from considering available evidence for a period that is of at least envisaged to be 10 working days, so about 2 weeks in calendar days, and up to 18 working days, and so significantly more calendar days. So that's the context in which the judge was saying it's more than de minimis. It's a period envisaged to be at least 2 weeks. Thirdly, it creates a likelihood of harm to vulnerable individuals, in particular those held in continuing detention whose MLR would have been assessed at level 3 and who would otherwise not have been detained.
Well, would otherwise have been released.
Exactly. So we submit that none of that is consistent with the statutory guidance, which we've seen contains a clear presumption against detention, has a stated purpose to reduce the numbers of vulnerable people in detention and the length of that detention, and requires levels of risk to be assessed on the basis of available evidence.
You keep emphasising available evidence, but available evidence, that by itself is totally neutral, isn't it? Does it mean available at the very moment the MLR comes in, or does it mean available in the sense that you can get it in order to assess the position in the light of the MLR?
Well, it's available in the sense that it is there on your desk and available to be considered.
Well, that's not necessarily what available means. If that wasn't the context, you'd say available evidence would be perfectly natural to say that available evidence means evidence that you have got or can easily get.
But that's not available to the caseworker at the time.
No, but you're assuming that it has to be available to the caseworker at the time, which isn't what it says.
Well, if it's not available at the time, then it can't be considered.
But you're assuming what you've got to prove. All I'm putting to you is that the word available is neutral on this point, because but for the context, available doesn't necessarily mean on the desk at the time. It also means evidence that you can get.
Well, my lord, but if you read it in the context...
Well, all right, I'm trying to focus on the fact that the word available doesn't really give you the answer. What gives you the answer is your overall point about the statutory context.
Yes, it has to be read together, and in a common sense way, if you're being required to take account of available evidence, then that's evidence that is before you at that time. I appreciate your lordship's point that you know, if one looks at Ladd and Marshall, to move out of the context, what is available may not necessarily be on your desk, but is within your power to obtain. But that's in my submission, not the sense in which it can be seen to be being used here when you're requiring a caseworker to make a decision on available evidence.
Can I ask it ask a different question, actually? Assume you're right about what available evidence means, so it has to be something to hand. It then follows that when you make a decision, you have to make a decision by reference to what is to hand. Where does it say you have to make the decision at any particular point?
Well, it says that through the statutory guidance.
Where does it say that? I can see it says...
Well, it doesn't say you must make a decision within 1 day or 3 days, but it is, the statutory guidance is very clear that if you read the presumption against detention together with the stated intention to reduce the period of time that vulnerable people are detained for, you can't justify holding off from a consideration of your decision.
Can I test it a bit? Can you at least justify more than a de minimis period? Where does it say you can't take longer than a de minimis period to make your decision?
Well, one can argue about de minimis, and the example that appears in the judgment was of a day when there's a pre-arranged appointment, and there's only an example, and Miss Liu conceded below, and I would concede here, that if one took that example, that isn't going to be a breach of the requirement to form an assessment on the basis of the available evidence. So whether a day is de minimis or a day is acceptable, it falls within what's envisaged and required by the statutory guidance. We're looking at a much more extreme case.
Can I take a middle case? Suppose you think, look, I can get hold of the transcript from the first year tribunal in a week. At that point, there will be, one way or another, more evidence available to me. Why is that impermissible?
Well, it depends what you think this transcript is going to say. If you've got no reason to believe the transcript is going to cast doubt on the MLR that you've got available.
All right, I better take a different example. Suppose you know, and obviously this is not the second opinion policy, but suppose you know you can get a report from a different doctor within a week.
Maybe the treating doctor has been away for a week and he'll be back next week and be able to tell you what he found. Sorry.
So why can't you defer your decision by a week?
I'm just trying to see how that would emerge in practice, because the burden is on the detained person to produce the medical evidence. The Secretary of State, absent the second opinion policy, does look at the healthcare records, but, well, the healthcare records are taken into account.
But
and has a...
Let me go back to self-declarations for a moment. So you get a self-declaration. The person says it's all terribly serious. And you think, look, I can get a doctor to check on this in a week. On your case, that's wrong?
No, and that goes back to the previous example that we were considering, that level 1 is likely not to lead to release.
But in your case, you have to make a decision at once.
Yes.
You can't wait the week to get the medical evidence.
Well, I'm uncomfortable about prescribing precisely what the number of days that would be acceptable. 1 day, I think we all agree would be acceptable. Would 2, would 3. And there's some point on that scale where it becomes unacceptable, where it's more than day
Why
minimis.
axiomatically is 18 days not somewhere on the scale?
Because that's a very substantial period of time.
It isn't. Maybe the person's been in detention for months.
There's only now got an MLR.
But you've got an MLR on this hypothesis of someone who's at level 3 likely to be caused harm by continuing detention. That has a substantial impact on what one could consider to be a reasonable interval or more than de minimis interval.
There's a shift there. As you say, maybe it's a question of reasonableness, not de minimis.
Well, I would submit that the two elide in the context of a vulnerable individual likely to be caused harm. Anything more than de minimis is unreasonable.
But this is becoming a different challenge. You could challenge the second opinion policy on the basis that in the kind of case you're thinking, as much as 30 days, which is what you say it could be in an extreme case, is too long. And there ought to be a shorter period. But we, all the way up in this case, well, not all the way up, but certainly at first instance and now here, are only concerned with statutory construction.
Yes.
And if what you're really coming to is that there can be on the proper construction, there can be a reasonable inference, a reasonable interval, depending on the circumstances, between the moment of receipt of the MLR and the decision, during which further information is sought, then the second opinion, then there's no necessary inconsistency between what is done in the second opinion policy and in the statutory guidance. Well, statutory guidance says, reading between the lines, that there can be a reasonable interval, and the issue then is whether as much as 30 days could be reasonable, but that's not the issue before us.
My Lord, the statutory guidance doesn't, with respect, I don't think, indicate that there can be a reasonable...
Well, but that's where we were getting to in the helpful exchange between you and my Lord. You were accepting perhaps not de minimis, but reasonable.
Well, I'm not distinguishing between de minimis and reasonable. Anything more than de minimis is, in this context, in my submission, unreasonable. The context being, of course, of someone who's likely to be suffer harm as a result of continuing detention.
While we're looking at timescales, there is no timescale for the caseworker to review the MLR. All we know is that it's got to be done quickly. Contrast Rule 35s, where if you look at the supplementary bundle at page 264, and as is well known,
yes,
there is a 48-hour period. What do you say? I mean, I suppose you've got the point that even if I look at it after 3 days, it's not a Rule 35 report. 3 days with my other workload might be sufficient. I'm now putting in another sort of 10 days on top of the 3 days. Is that your point?
Well, yes, it all compounds.
But would you say, once I've received the MLR, given that the judge said 2 days, I mean, he's effectively written in to the statutory guidance the equivalent to page 264 for the Rule 35 reports?
Well, that may be in practice what is required, but the process is underway. I accept that the moment the MLR lands on a caseworker's report, they can't be expected to make a decision. There has to be an interval to make that decision, and that's inherent in the pre-existing system. That doesn't fall for consideration under the second opinion policy. That's what a caseworker does, and as my Lord says, there isn't a prescribed time, but maybe it's 1 day, 2 days, 3 days. There's an interval to consider it and make your decision based on it.
But the objection is then that once the decision is made, then there is, on any view, a hiatus of at least 10 days.
Well, there's sorry, are we in the second opinion?
If you then have the second opinion.
Back in the second opinion policy application, the MLR is considered, but only for the purposes of does it meet the baseline. Then it falls automatically into the second opinion policy, so is left on the desk not considered further, whilst the process of the second opinion policy works its way through for 2 or more weeks, up to, as we've seen, 18 working days. And that is what we submit is clearly, and we can look at intermediate cases as to what de minimis actually means, but if we're looking at the actual effects of the second opinion policy, there is no doubt in our submission that it is inconsistent. It's more than de minimis. De minimis I equate with reasonable, because anything more than de minimis in this context is unreasonable. And we submit that it's no answer for the Secretary of State to point to the fact that under the process, the MLRs referred to the healthcare team, because the healthcare team aren't empowered to take detention decisions. And exactly that point was highlighted. Well, the submission was made by Mr. Payne in this appeal, as it had been by Ms. Anderson below, and was recorded by the judge at paragraph 52. That feature of the second opinion policy. And as we submit, it's no answer to say that the detention is subject to reconsideration in various circumstances if circumstances change.
Can I just, sorry to interrupt,
No.
just to finish off on the Rule 35 point, which has always slightly troubled me in terms of the interrelationship and doesn't seem to have featured so far. Once it's referred to the medical team, I agree they can't obviously take a decision. But if they then say, well, in the light of this report, I raise a Rule 35 report, and then you actually can be quicker than your sort of 10 working days or 18 working days.
Yes.
And isn't that, and just so that you can deal with the point, isn't that the answer to your obviously right points about the direction of travel of the statutory guidance, which is detention as a last resort, as it were, the presumption against it. Don't keep vulnerable people there. You get the MLR, you give it to the healthcare team and say, oh, scales have fallen from our eyes. We realise that we now need to assess you. And we raise the Rule 35 and you get out.
Well, that might possibly happen in some circumstances, but it is not a reliable safety net by any means.
Great.
So,
Well, why not?
well, because the healthcare individual in the detention centre is not assessing it for the purposes of Rule 35, but not the exercise which the caseworker under the caseworker guidance is doing, which is the very precise level 1, 2, 3 exercise, and then the balance against immigration factors.
Why is it an exercise that's less likely to lead to, maybe different mechanically? Why is it one that's less likely to lead to release than the exercise which the case manager will be doing?
Well, because the test is different. Can I turn my back and seek some assistance? My Lord, as I understand it, and I'm getting beyond my immediate experience, but Ms. Liu is deeply experienced. The Rule 35 process has 3 levels, and if I've got this correct, only Rule 35(1) will lead to a level 3 assessment. And there's no reliable basis.
We've got reference to Rule 35
Yes.
in the guidance, I know, but perhaps that's
In the
right place.
caseworker guidance, yes.
Yes, that's the place to find it.
Yes.
Perhaps we could just look at this.
Page 263.
Or 227. Is
So, my lord said 263 and you said?
I said 227. I'm not.
Well, there is a reference to it, but if you want the detention general instructions, it's 263 and then on.
Yes.
Which is probably a more comprehensive. It's not wrong at 227, but it's
Yep.
More cryptic.
The at 227, one can see the bullet points which allocate levels.
You say levels, they're three different kinds of person about whom a report must be written.
Yes.
And the first one asks the same sort of question as the statutory guidance, doesn't it?
Yes, once you've got the report.
Yes, but I thought we were hearing that the report, the MLR routinely goes to the Rule 35 team, isn't it? Well, I call them the Rule 35 team. I mean, to the medical team at the detention centre.
Yes, the MLR goes there. So let me.
I don't want to take over my lord's point, but because I suspect he may have a better feel for how this goes, can I just explain what I understand is happening? The MLR goes, I think it's required to go, we saw yesterday, within 24 hours to the medical team at the detention centre.
Yes.
It is reasonably to be presumed that they will read it. That's why it's been sent to them. I am imagining what would happen then is that, having read it, they would form their own view as to whether the health is likely to be injuriously affected by continued detention, and would perhaps, if there was a doubt, or almost certainly in practice, would ask to see the detainee and carry out their own examination, at the end of which they would report saying, in my view, the health either is or is not likely to be injuriously affected by continued detention.
My lord, I accept that there are other routes by which a person may end up being released.
Yeah.
But it gets back to my submission. It's not an adequate safety net, and it's dealt with in broad terms, at least, this submission at paragraph 75 of the judgment, when the judge says it's no answer for the defendant to say that there may be cases where a decision to release a person is taken whilst the second opinion report is pending.
Sorry, yes, judgment where?
Paragraph 75.
Yeah, thank you.
And then without express reference to section to Rule 35 or 32.
Could I just ask whether, either in the context of Rule 35 or indeed in the context of the statutory guidance, there has been any judicial consideration of the meaning of the word likely?
I'm not getting.
No, I suspect not. we all know the old conundrum, but does likely mean 50% plus
exactly.
one or the cards, and depends on the context. I suspect this is a case where the context is not an arithmetical one.
No, when one's talking about likelihood of harm to a person who's vulnerable,
right?
That's it.
Though logically you would distinguish the likelihood on the one hand and the degree of harm on the other, they would also tend to meld into one another.
Exactly.
So you couldn't take an arithmetical approach. No. Okay, thank you. I just thought I'd better check on that.
So, my Lord, I think where I end up on my Lord Justice Dingemans' line of questioning is the headlines point, it's not an adequate safety net, and the judge considered that and also considered it was not an adequate safety net to say, oh, well, they may get out anyway under some other route under the policy. So turning then just to conclude on this point is to see the way the judge dealt with it. And I know your lordships are familiar with this, but after a detailed consideration, including a rehearsal of both parties' submissions, we get to paragraph 69, where there's the important starting point, which, as I understand it, is not in dispute as to the approach that it is proper to adopt in relation to the interpretation of statutory guidance, namely that it's for the court. And then paragraph 70, again, as far as I understand, not in dispute. The starting point is for the Secretary of State to justify the detention, with the addition when you're dealing with someone who's vulnerable, that greater justification will be required when the circumstances of the individual mean that they are vulnerable whilst in detention. And then paragraph 71, the judge's reading of the statutory guidance, and we've looked at the statutory guidance earlier. He's rehearsed it at much greater length previously in the judgment and is pulling together what he sees to be the key components of it. And then paragraph 72, the inconsistency, for there to be material delays, seems to be in contradistinction to de minimis, in acting on the available evidence, and that a person cannot be held in detention when the evidence available to the defendant shows that this is not justified, contrary to the guidance for it to be more than de minimis. So then, importantly, in paragraph 73, he expresses the limits of the effect of that conclusion. Doesn't mean the Secretary of State can't obtain his own second opinion or her own second opinion.
Well, pausing there, that's true, of course, he can do whatever he likes, but the point is that if the detainee has been released in the meantime, in circumstances where there are, by definition, immigration factors legitimately requiring his detention, or in favour of his detention, maybe in some cases very powerfully in favour of his detention. Once he's released, there are always going to be difficulties in getting them back. Well, though release is an important point, you can't just say, well, he can get a second opinion and then re-detain.
But release is subject to conditions, so it's not free range. And that's always going to be the position. If you've got someone who you want to remove, and they're released. I mean, that's factored into the decision making, the risk of absconsion and so on. So there would be the ability to, well, there is the ability to impose bail conditions to appear in front of a particular person. So there are options available to the Secretary of State short of detention to make such further inquiries. And then paragraph 74, returning to his main theme, cannot be any real doubt that the statutory guidance, the second opinion policy directs caseworkers systematically to postpone a decision in the cases to which the second opinion applies, rather than make a decision on the evidence which is now available to them in the form of external medical report. And so on. You'll have read that for yourselves. And then the paragraph that I alluded to earlier in my exchange with Lord Justice Dingemans, paragraph 75, no answer for the Secretary of State to point to routes which may or may not lead to a decision to release being taken earlier. And then at 78, what it distills down to in the second sentence, the simplest way of expressing the point is that statutory guidance was required by Section 59 to be approved by Parliament, albeit. Sorry, it's the opening words of paragraph 78, which I wanted to highlight, not what I just read. If one considers whether it would be unlawful for the defendant to promulgate a policy which contradicts the statutory guidance, I did not understand Ms Anderson to argue otherwise. And similarly, we don't understand the Secretary of State on this appeal to argue otherwise. The question is does the second opinion policy contradict the statutory guidance? And you have our submissions on that. So, my Lords, those are our submissions on ground one.
That's very helpful. Just one point that's been irking me and I've been meaning to ask. Where do we actually find what the basis of your figure of 30 calendar days as the absolute maximum that the second opinion procedure might take?
I don't think I said 30.
You said 18, but then you said it could be as much as 30.
Well,
I may have misunderstood.
Well,
just tell me again how it works. Risk of repeating.
So the way it's set out in the judgment is at paragraph 55. 55, which is recorded as the claimant's submission, but not apparently doubted, and it seems to follow from a pretty straightforward.
Yes, that's right. Well, that bit I got, but did I imagine it, or I thought you did say 30 days?
He did say 30 days once.
Did I? If I did, I'm sorry.
What this says here is, even if the deadlines are adhered to, it may delay the decision about whether they should be released for up to about 18 working days and significantly more calendar days. Well, depending exactly, one can do that within a day, effectively, depending how the weekends fall.
Yes.
But it can't be more than, that would get you up to 20,
yes,
I'll do the rest of it in my head, 23 or something. But, then there's also no deadline by which a caseworker is required. Were you perhaps adding a few days for the caseworker then to have a look?
I hadn't consciously. So,
it's 27. I think is what
But that's what we should be looking at.
Yes.
We should be looking at 18 working days.
And then
maximum,
adding 6 or so.
Looking at adding for weekends.
Adding for weekends, and then adding for the time for the decision to be made.
30 may be accidental, but you could potentially include 4 weekends, I suspect.
Sorry, my lord.
I suspect you could potentially, on a certain scenario, include 4 weekends.
You might get to 30.
Plus a couple of days at the start.
So 4 weekends, so that would be 8 on top of 28
And
would
bank
be
holidays.
26. Yes, I see. Well, 30 may have been divine inspiration. You can, one can see it could be almost that.
I think I've been handed a note to look at paragraph 36. On our skeleton.
On your skeleton.
No, the skeleton below.
Which is in the core bundle. So I did look
Yes,
at
at page 163. Which gives a period of 17 to 28 calendar days is where that calculation gets to.
Yes, I see.
I mean, I'm
No, don't worry. It was only I thought I heard, and luckily it wasn't only just me, thought I heard you say 30, and I couldn't recognise that particular figure.
Well, I do apologise. I hadn't consciously said 30, and I wouldn't have been able to justify it, even though one can actually probably get up to 30.
No, 36 is very helpful. That shows how you could do it. Yeah.
The uncertainties are the length of time that the caseworker will take.
Well, no, I mean, frankly, no need to spend any more time on this. It's just that if one is writing the judgment or wants to get it accurate.
And the points I've sought to emphasise is on the face of the policy, it's going to be at least 10 days because it's envisaged.
Yeah, I understand that.
10 working days.
The case doesn't depend on extreme scenarios.
10 working days because it's not possible to complete the process shorter.
Okay, that's enough on round one.
Okay. Ground 2, our skeleton at paragraph 66 to 76, our headline submission is that this is an attempt to displace what was essentially a finding of fact by the judge pursuant to or an evaluative exercise. That finding was based on his review of the evidence, extremely thoroughly considered. One sees set out extensively paragraphs 105 to 130. Considers the defendant's pleadings and evidence, paragraphs 134 to 148, and is carefully analysed in an extended section, paragraphs 156 to 164. And it's instructive, as I would submit, to see how this is formulated in the claimant's grounds. Core bundle, page 14 is the first page of the grounds. But this is the second ground, page 15, within the core bundle, which is the basis on which permission was granted. The High Court misdirected itself in law when finding that the claimant had a legitimate expectation of consultation. Now, as we submit, seeing how that ground has been developed.
Well, perhaps I'm not.
I'm going to go on to the
point, but it's particularised under 3 bullets.
Yes, and precisely, my lord. And I was going to to come to that, looking at the headline to make the point that it's not possible to divine a misdirection in law. And if one looks to the bullet points, what one can see and is exposed is that this was really a challenge to the judge's conclusion on the evidence, saying that he erred in his approach to the evidence, he misapplied the high threshold that he identified for himself, and failed to give due consideration to
so these are all the weasel words you find where someone is trying to
when someone's dressing up
evaluation into a
exactly. I wouldn't be so. Wouldn't use the words weasel words, but I'm not jaded by having heard such grounds formulated as often.
Well, perhaps it's rather unkind to Ms. Anderson, but they are the sorts of formulas that are used.
Yeah.
I take your point.
So this is a challenge dressed up as a point of law, which really is a challenge to an evaluative exercise. And one can see, doesn't need to take up time on it because it's not suggested that the judge misdirected himself in law. The suggestion is he misapplied that law to the facts before him. But paragraphs 90 to 96
of the judgment. Sorry.
Are the relevant, really 90 to 94, because we're in the context of established practice. With the culmination at 94 of the reference to my Lord Justice Newey's judgment in MP itself, relying on the Bapio action decision. And then that's picked up again after his extensive review of the evidence and pleadings, paragraph 159, when he asks himself what's patently the correct question. And expressly, fifth line down, recognising there's a high bar, and indeed that's one of the reasons in that paragraph as to why he confesses to hesitation.
Which paragraph are we on now?
Paragraph 159, my Lord.
Yeah, thank you.
So he's expressly recognising and applying a high bar. And the hesitation doesn't help the Secretary of State. Rather, it confirms the correctness of the legal test in fact being adopted and applied. The two other matters which one can see caused the hesitation is that the consultation described did not follow a uniform or standard pattern, and that's addressed, and that Ms. Hanley had not exhibited the underlying documents, also carefully considered and addressed. Importantly, and Mr. Payne took you to this, but it's not unfair in our submission for the judge to have said that the evidence was effectively uncontradicted by evidence from the defendant. And that was a very important point. And at paragraph 161, he deals with the concern that there was a lack of uniformity of approach. But concludes the key point, and in our submission this is clearly correct, that what matters, last three lines, is that the claimant was consistently consulted in relation to material issues arising in this area, regardless of who else was. And the words "in this area" are important. It's always been the claimant's case that it's in the area of adults at risk, not more generally.
Adults at risk in detention.
Adults at risk in detention.
Yeah.
So it's a limited but consistent on Ms. Hanley's evidence and then the lack of, and then that's elaborated upon in paragraph 162 when the sentence on the third line, evidence establishes a clear pattern of seeking the views of the claimant in relation to policy proposals and changes in the area of adults at risk. Express reference to the gunning criteria, so he's not overlooking that. And a finding that on those facts, a legitimate expectation was generated. And there's a point which we develop in our skeleton argument. I won't, in the interest of time, develop it now, but making clear that there is a distinction to be drawn between the duty to consult and aspects of the consultation that may have happened during the course of the history that may or may not have fallen short of formal consultative processes. The duty arises from the consistent pattern, and so it's the pattern which is correctly being considered and identified by the judge. And then paragraph 163, the significant point, which I'll return to in a moment, that the defendant, in relation to the lack of underlying documentation, had not taken the point or sought to have the documentation or any of it put before this court. So, my lords, Mr. Payne's submissions yesterday consisted very largely of a quite detailed review of Ms. Hanley's witness statement, and with a recurring theme that there was a lack of sufficient clarity to establish the practice of consultation, and that what she does describe lacked what he called the hallmarks of consultation. And in our submission, that is simply not a fair characterization. I'm not going to go through the same exercise because there simply isn't time, but what your lordships have now is our note produced, as I've indicated, by Ms. Liu overnight. I no doubt inappropriately popped up yesterday when Mr. Payne was going through the exercise he was to complain that none of this had been foreshadowed in his skeleton. But now that we've seen what he says, in our submission, the points he makes simply aren't well-founded on a fair reading and a cross-referencing of what Ms. Hanley says with what the judge recorded and found in his judgment and went on to conclude, applying what we all agree to be the correct test. A series of short points
Yes, thank you.
in relation to this. First, Mr. Payne's repeated complaint of lack of clarity seems somewhat surreal in circumstances where the Secretary of State herself is in possession of all the key material. The minutes, the emails, the court settlements, and so on. Furthermore, the Secretary of State was, and indeed remains, under a duty of candour to produce relevant material that's necessary for the determination of the issues on the claim. That was not produced before Mr. Justice Linden, and no attempt has been made to introduce it now. Obviously, there would be some.
It's complicated to talk about the duty of candour. Everybody knew these documents existed. Both sides had most of them. Both sides took the view that it was unnecessary to produce them.
Yes.
Now, quite where that leaves us is for consideration, but I think it complicates it to a lack of candour, which has a pejorative ring.
Well,
it may well be that a bad forensic decision was made by the Secretary of State, but it's not really lack of candour.
Well, and no doubt by the claimant as well. I mean,
yeah, well, absolutely. I made that point yesterday, but yeah. Anyway.
But I make the point in the context of Mr. Payne's submissions, then he repeatedly said, well, we simply don't know. We don't know what the nature of this consultation was. It's not described.
But what he meant was, the claimant hasn't said. It's basically a burden of proof point.
Well, and that's how the judge ultimately addressed it and found that the claimant had discharged the burden of proof, taking into account that it could and was open to the Secretary of State to call for the underlying documents, to produce the underlying documents herself or himself, whichever it was at the time, and to produce evidence which contradicted what Ms. Hanley was saying, include beyond the sort of one line that was referred to by the judge, and say, you're quite wrong. There wasn't consultation, or this discussion had a completely different flavour, or we've had a whole series of other policies that you simply haven't mentioned in your witness statement that were relevant to this area. But what you have, what Mr. Justice Linden had, was, as he says, an essentially uncontradicted account. And for the Secretary of State now to say, well, we don't really, it's not clear what she was saying, it doesn't lie in her mouth now to say, well, there's a lack of clarity, which means the judge wasn't entitled to reach the decision that he did. The judge was aware of the limitations of the evidence, expressly considered them, and to get back to my headline point, was entitled, as we submit, to reach the decision he did.
Yeah.
Second point, we accept that whether the label consultation is used or not is not critical either way. It may be used and not establish the necessary degree of consultation that contributes to the pattern, or it may not be used, but notwithstanding that, there still be consultation within the necessary definition. So the labels are, we accept, not determinative. They may be relevant, with all due respect to Mrs. Justice Elizabeth Lane, and one notes that she said legally relevant, and that may be the point of distinction. Factually, it's maybe of relevance, but as I accepted, not determinative. But the key point is, and this is the approach the judge took, apparently with the approval of both parties, that this is a matter of substance rather than form. Paragraph 162, in addressing Ms. Anderson's arguments that there wasn't a set machinery or procedure for consultation, but the parties agreed that the question is one of substance rather than form. So that was the proper approach that the judge was adopting, incorporating and clearly aware of by his express reference to them, the Gunning criteria. Thirdly, it is of no significance whether the trigger for a proposed amendment to a policy or a new policy was a judicial decision, an agreed settlement, or some other political imperative. That, I think, was advanced by Mr. Payne yesterday to suggest that, oh, well, where the courts have imposed a requirement to amend, then that's not really falling within the pattern of consultation required. We would respectfully reject that. Fourthly, both Bapio Action at paragraph 39 and my Lord Justice Newey's summary in MP, which, as you now have it, is paragraph 53, cited by the judge at paragraph 94 of the judgment below, make clear that a practice does not necessarily have to be unbroken in order to have the consistency required to be tantamount to a promise. I say that, but on our case, and as accepted by the judge, it was essentially an unbroken consistency or unbroken practice, with the only points highlighted by Mr. Payne, but were points which related to minor and insignificant amendments to the policies at issue.
Can I just ask you about that?
Yes.
You know, and if that takes us too long, I'm sorry, but because this is something that, if one is looking for consistency, it's 78, 80 and 84 in Hanley's statements. Exactly,
and there's a section in our table, the very final section of the table,
which I've not helpfully seen it read.
No.
But so you say it's answered in the table. Can I just ask, particularly paragraph 80, we were notified when the DSO was updated on the 5th of October 2022, clarifying the DSO applies to people who refuse foods and fluids for reasons other than protest and other aspects of it. I mean, those are, you know, relevant changes, and just to deal with whether or not that is just a minor change.
Sorry, my lord, I'm just turning it up.
It's page 97 of the supplementary bundle. Sorry to spring a specific question, but Mr. Payne had referred to it yesterday.
So, if one reads the opening, or the second sentence of the paragraph, well, perhaps the first sentence, since its publication, the DSO has broadly remained the same. 2019, some operational changes internally as to the division of work on this issue between different Home Office teams, but that did not alter the substance of how the DSO operated. And then she makes the point that even that was notified, but that's really nothing.
That's not consultation.
That's not to the point.
Regardless of how you describe it.
And then then working through, one sees similarly notification to clarify the extent that DSO applies to people who refuse food and or fluids for reasons other than a protest. But that's not a significant, as we would submit, material change to the policy. And then the concluding sentence, other changes, all minor, did not alter the substance of how the policy operated. So that does, as we would submit, not constitute a break in the pattern of consultation on every material change to a policy.
And you would say that the question whether it did is a classic example of the sort of question that has to be left to the evaluation of the judge.
Yes.
Well, you might also say in relation to 80, if you're dealing with events in September, October 18, 2022, that's very late in the context of a claim that was issued in December 2022, was it?
Yes, and I suppose, and I haven't thought through this point, but it's almost coterminous with the issue of the policy. So the consultation would have been, and the legitimate expectation would have predated that, if one's looking at the 29th of September 2022 date.
And sorry, just while on that point of asking the question, what do you say, will the answer be in the document you very kindly provided overnight? What do you say to Mr. Payne's point, which is, if you actually look at it, this is all DSOs and not every single policy?
That's, I think, about my point 9, but I'll address it.
Sorry.
No.
Well, I didn't take it out of order. It was just as long as it's addressed.
We're up to point 4, are we?
We're up to point 4.
Yeah.
Doesn't necessarily have to be unbroken. And then in alliance with that is the point I made that's developed in the skeleton, that one looks at the fact of the consultation rather than necessarily the quality in each instance along the chain of practice. And then the 5th point was in relation to the minor amendments. Our submission is that the specific instances, paragraph 78, 80 and 84, where there hadn't been consultation were in relation to matters that did not affect the substantive operation of the policy.
Yeah, well, that's the one we just...
And were minor.
Yeah.
And then following on from that...
This is 6, is it? I'm sorry.
6.
Yeah.
The COVID example that Mr. Payne alighted from by reference to the minutes, we submit does not constitute a substantive policy amendment. All that was happening was that in June 2022, or in the minutes in June 2022, the interim COVID guidance had been withdrawn, or the pandemic had passed by then. That's not a substantive policy amendment that breaks the chain, disrupts the pattern. Seventh, when asked to identify the hallmarks of consultation that he said would be required, what Mr. Payne came up with by way of response was very much in line with what Ms. Hanley describes, and the judge had labelled as being in broad terms compliance with the gunning criteria, paragraph 162. Eighth point, Mr. Payne's distinction between detention service orders on the one hand and operational guidance on the other is not, in our submission, a material one. There is no difference in status. Both constitute non-statutory operational guidance. In the taxonomy, DSOs, detention services orders, are directed to those working in detention centres. Other operational guidance is not labelled DSO, but there's no relevant distinction for our purposes. They're all operational guidance. Operational guidance directed to those working in detention centres gets given a particular label. There's no relevant distinction.
Understanding that point, does that mean that your client has been consulted on all policy changes up to this one, or anything that engaged adults at risk in detention?
Yes, that's Ms. Hanley's evidence. So, and ninth point, the reference to 60 DSOs, Mr. Payne saying, well, there are all these DSOs out there, and Ms. Hanley isn't suggesting that she has been consulted on all of them. Quite right. but only a very small, only a minority of them, I won't commit myself to a quantification, a minority of them are relevant to adults at risk. One can look at the Home Office websites I did this morning. There are 58 DSOs currently, all in line with the 60. And they cover a vast range of areas. Matters like access to video calls, internet, tagging, escorting detainees with cash, extremism, fingerprinting, detainee escort, so on and so on and so on. So the point is that there is only a small minority of them. Mr. Payne can't say, well, there are all these DSOs and medical justice hasn't been consulted on them, so there's no consistent pattern. The case always has been that it's consistent consultation in relation to adults at risk policy.
And to the extent that you've just given evidence, you would say, well, they're challenging the facts and they've given evidence about all these other ones being out there.
My Lord, yes, it's publicly available.
I was only, but also I wondered actually whether the figure of 60 was just, did that come from?
That was referred to in the minutes in
Yes, I see, yes.
Exhibited
Well,
to.
I think
It wasn't, if I had to defend myself on that, it's not a point that has ever been raised before we heard it in oral submissions, and it's a bad one.
At any rate, you say there is no evidence of a DSO dealing with adults at risk that was not consulted.
Exactly. And it would be easy it would be easy and obvious for the Secretary of State to be able to do so, if there were one. So, my Lords, the judge, to return to my starting point, was fully entitled to find, as he did, paragraphs 159 and 162. That's sufficient to establish that he was not wrong for the purposes of founding a sustainable ground of appeal within the terms of Rule 52.12, Rule 52.21.3. Both BAPIO action and MP, BAPIO action paragraph 39, MP paragraph 59, confirm that this is an exercise that is an evaluative one for the judge at first instance.
So paragraph in MP was 59?
59.
Thank you.
Insofar as it's necessary to do so, we would submit that he was also correct if the court was reaching its own view. But in our submission, that isn't the proper approach.
Can you, final question, just deal with Mr. Payne's other point, which was that there's an internal inconsistency in the judgment between paragraphs 138 and 160, which I don't think featured in your list of 9.
No, I think it might have eluded me, that point.
What he said is that if you look at 138, this plea seeks to avoid confronting the fact was not alleging a practice on consenting any and all. And then the clear allegation was that the consistent practice of the defendant was to consult on material policy developments and changes concerning adults at risk. And then if one looks at it, the finding at 160 is consistently been invited to respond to consultations concerning immigration detention, healthcare arrangements, management of risk to and safeguarding of detained persons.
Yes, well, if one, it's less precisely framed in 160, but if one looks at Ms. Hanley's evidence, it is restricted to the terms of 138. It is adults at risk. There's never been a broader claim than that. One can trace it through. I can give you the references to show that that's always been the claimant's case. Our statement of facts and grounds, paragraph 9, core bundle, page 281. Reply to the summary grounds of defence, core bundle, page 211, paragraph 31. Skeleton argument below, paragraph 71, 72, core bundle, page 173. And that's what leads to the more accurately and narrower recording by the judge at paragraph 131. So that's not a material difference or inconsistency. It may be that the judge was less precise in the formulation at paragraph 160.
Well, 160 actually comes from paragraph 17 of Miss Hanley's statement, as far as I can read. And sorry to ask these direct questions.
No.
I'm just picking up points that Mr. Payne made. The final sentence, on page 78 of the second bundle.
I think that she may have different formulations in her own.
Well, that's. I mean, Mr. Payne's point is yes. If even accepting as we have to the judge's findings of fact, in fact, if you look at Miss Hanley's, there are different ways she's phrased it, and it's too uncertain to form a practice, and it's just dealing with that point.
Yeah, I mean, if one looks at paragraph 17, it's framed by reference to processes relating to the identification of vulnerable people and decision-making about their detention. So one can't just extract the last sentence of paragraph 17 without reading it in the context.
For what it's worth, there is a difference between Ms. Hanley's paragraph 17 and what you get in paragraph 160, because 160 leaves out the words "a range of."
Yeah.
And can I just also, just as a matter of fairness for you to deal with...
Sorry, so my lord, I mean, my answer to that is read paragraph 17
it's the same
in its context.
Yeah, and then the other point was, on a range of, doesn't suggest consistency, as it were.
Well, but if one goes on and reads the, puts the cold towel around one's head and reads the whole of the statement, that's precisely what she's saying. And then the last, I suppose, I'm not sure what the range doesn't dilute the word consistently.
It could mean subset, I suppose.
I mean, the range indicates that within the set, this may be my last point, within the category of policies consulted upon in relation to adults at risk, they cover a range of subject matters, and that's indeed what is set out.
I wonder whether part of the complication here is that the medium for or the forum for the consultation in at least some of these cases was the detention subgroup of the National Asylum Forum, whatever it's called.
Yes.
Which clearly does consider a wide range, certainly doesn't only consider adults at risk. And that's clear both from the terms of reference, which we have at 1, 2, 3, which refers simply to matters relating to immigration detention, and is confirmed by the range of people who are members of the subgroup, and the kind of topics we see in the minutes, things like
Yes, and maybe a
the
broader
Miranda scheme. So it's not a point Mr. Payne made, I think probably rightly, but it's not part of your case that the existence of the group means, and its activities over the last however many years it's been in place, means that there is a legitimate expectation of consultation to every member of the group on all topics relating to immigration detention. You, even though the group may have a wider focus, you are focusing only on the fact of consultation, whether through that group or otherwise, on matters relating to adults at risk.
Exactly.
Is that,
yes, with medical justice.
Yes,
and so medical justice.
That's what I meant, with medical justice.
And that's what...
So to some extent, I mean, the existence of the subgroup is helpful to you to some extent because it suggests a degree of formality and regularity. But actually your case it has to be and is more refined than that.
It's not only through that means,
yes,
as described by Ms. Hanley, and one can follow the table through. The big advantage of the table is that it adopts in relation to each policy it sets them out chronologically.
It's not clear actually from the table, which simply tabulates what Ms. Hanley's statement, how many, although she gives evidence about the existence of the group and exhibits in terms of reference minutes, not clear how many of these consultations actually occurred in the forum of the group. I think that is just unclear, isn't it?
That may well be so.
They mostly didn't.
That may well be so, and that goes to the lack of uniformity of approach, which was expressly considered by the judge.
Yes. Well, I don't want to fall into the trap of the judge of cross-examining Ms. Liu and then getting it all out of his mind. But just in terms of what the evidence shows, it doesn't show that the consultations on which he relies and you rely took place through the group.
Not exclusively.
Not exclusively, no, all right.
Yeah. I don't entirely accept that. It feeds into the, as I just said, the lack of uniformity.
Sorry to ask.
So, no, my lord, not at all. So those are our submissions on ground 2.
Yes.
I've now extended...
There's enough time for you to address us on academicness, but you won't have to do so for long because, well, it's your point, I suppose, but Mr. Payne didn't. It's a short point.
Well, it's a point that is, as we submit, an important point of principle, but it loses or has lost a degree of its practical importance.
That is true.
From the fact
you might spare one or all of us from having to write judgments on the point. So if it is academic, we probably shouldn't deal with it even if we've heard argument. But still, well, I'm just playing with you.
I would venture to advance the point. On one view, it may spare you from having to write a judgment on the point, but you might adopt the position of Mr. Justice Silber in the Zoo Life case, who found it was academic, but nevertheless went on.
Well, that's not just him. I mean, that's in the law about academic. The first question is it academic?
Yes.
It's not academic. You've got to deal with it. If it is academic, you can nevertheless deal with it in special circumstances. That's fine. Yep.
And so, first question: is it academic? We have refined the point. So, as advanced before Lord Justice Arnold, we sought to apply it to both grounds. We've restricted it to ground 1 on review, and we do submit that it is clearly academic because there is now materially different statutory guidance and a new materially different statutory second opinion policy. So the key element of that is the statutory guidance, because that was the springboard for Mr. Justice Linden's decision. And I hope has reached the court the new version of the statutory guidance which was submitted at the end of, it was submitted on Monday.
I'm not conscious of having seen what I was told had happened. I don't think I've actually seen the document, but it may be my fault, is simply that, in effect, the relevant provisions of the statutory guidance, or the summary of the second opinions policy, are now part of the guidance. Is that, have I got that right? No. Well, let's see it.
Let me hand up the statutory guidance.
I saw something, but
It's
Well, it doesn't matter whether you've seen, whether we either have or should have seen it before. We have to get it now.
because of your familiarity with the previous version, it's a point that can be made quite short.
Yes, thank you very much. Yeah.
And the key paragraphs are paragraphs 8 and 11. And one can see that there is much of it's the same, but paragraph 8 alters the reference to available evidence, including evidence obtained on further inquiry, will reach a view. And then the reference to may require a reasonable period of time to obtain all the relevant information and make an assessment of all the evidence. Then paragraph 11 the reference to taking steps to obtain a second professional opinion in cases where professional evidence has been received, and then skipping the next sentence, your Lordship will see that it expressly permits.
Yeah.
So,
But the bottom line is, if this had been in force at the time,
I couldn't have advanced any of the arguments without
would never got off the ground. Yeah.
and the second opinion policy has been reissued in the light of this.
Yes.
Yeah.
I don't think it's necessary to. We can hand that up, but there's no point.
As you say, the touchstone of your case is the
statutory guidance.
Statutory guidance.
Yep.
Yeah. Okay. So that's why you say it's academic.
So that's why we say it's academic.
What about you're about to deal with the point that
Whether it
there's a
should,
risk of outstanding claims?
yes, I mean that's part of. There's quite a multifaceted response.
Yeah. Okay.
From,
You do it as you wish. Yep. Okay.
there's a procedural objection that was taken in the skeleton argument. I'm not sure if it's maintained below. That
I didn't get the impression it was. It didn't me very much.
Which, it is slightly important that, and this may not have reached the court as well, it was sent in, the amended application that we made last July, which expressly refers to the strikeout provisions. And due to our error, in the bundle is the unamended version.
Oh, I see.
But so what happened was that Lord Justice Arnold said this application doesn't indicate to me what the power or basis that I'm asked to dismiss the appeal is. So it was resubmitted, or it was amended, to indicate the express power under.
We may as well. I don't know whether we're going to go down this route. We may as well have the material while you're all here.
Yes.
And so the juniors have it.
Brilliant. Juniors.
Usher.
Sorry, that may be too.
Perhaps while that's just happening, Mr. Payne, you were under some time pressure, but you certainly didn't make the procedural point. I forget whether you expressly conceded it.
No, I didn't, but we're not going to take a procedural point.
All right. Okay. Well, there you go. Thank you
That
very
shortens
much.
it. For completeness, you've got the amended version, which spells out the alternative bases.
Right. Thank you.
My Lords, I'm conscious of the need to take this crisply. Can I do so in quite truncated form? Our starting point would be Zoo Life, Authorities, Tab 1, and this is quite familiar stuff. I don't think the legal background is essentially
we need
controversial.
perhaps to go to what's the proposition you're getting out of it?
The first is that it conveniently cites the relevant part of Salem,
Yes.
which is the touchstone authority that will be
Yes.
well familiar. And the propositions that we draw from it, from Mr. Justice Silber's review of the authorities, that firstly, the discretion to proceed with an academic issue should be exercised with caution. Secondly, the default position is that such appeals should not be heard. Thirdly, an exception may be made where there is, in quotations, good reason in the public interest for hearing the appeal. Fourthly, examples of such good reason are discrete points of statutory construction that are not fact sensitive and a large number of similar cases exist or are anticipated.
Yeah.
Fifth, the principle applies to all courts. Salem, of course, is the House of Lords, but it applies equally first instance and in the Court of Appeal. Sixth, costs are not identified in the authorities as a good reason in the public interest. In other words, cost recovery, where you've lost below, you can't simply. Seventh, court resources are a significant consideration in dictating the approach. With, as Mr. Justice Silver puts it, no court should use its valuable time hearing academic cases. I think there's a typo in there. I've left out a not, which clearly doesn't make sense, but so that's paragraph 37 and 44 of Zoo Life. And as I've already accepted, that loses some of its force when the point has already been fully argued. And then to similar effect, Rehoon, which is tab 10 in the authorities bundle and may well be familiar, is an example, and I appreciate all these cases will turn on their own facts, but it was a public law flavour. It was an entitlement to discretionary housing benefits, and that wasn't held for there to be a sufficient public interest. One recent example of a public law case that has become academic, and this is in a sense against me, is the case of BAA, and that's the one that I handed up, and unsurprisingly, it wasn't very apparent as to what the purpose of it was. Paragraphs 16 to 18 of that. One can see, and unhelpfully, we don't have, I mean, the vast majority of the case is entirely irrelevant. The only point is that this is an example of an academic appeal being brought by the Secretary of State. But with the condition that the respondent be indemnified for its costs. And I haven't been able to find what would have been more helpful, which is the reasoning of Lord Justice Popplewell in granting permission on that basis.
Yeah, it's not, yeah.
So it's,
there are lots of, we've all had cases like this, and they go both ways.
Yes.
I don't there's any doubt about the principles. Pretty well all your 8 points, or however many there were, however, are points about the exercise of the discretion if it is academic.
Yeah.
Mr. Payne's first point is that it isn't academic.
But, my Lord, if his first point is there may be damages cases, he was a bit inconsistent with respect. When you were first asked, are there damages cases, he said yes. And then when that was probed a bit further, he said, well, there are potential damages cases. Now, the Secretary of State would know and hasn't put forward any examples of damages cases.
You referred to your website.
He referred to the Doughty Street website, which is a news post in relation to this case as at first instance, which includes a reference to if you're affected by this issue, seek legal advice. Whether that's encouragement or not.
Yeah, I know that's perfect.
But the key point is that my solicitors and my clients are not aware of any damages claims arising from the application of the second opinion policy. I say that on instructions. Mr. Payne has not identified any. It's inherently quite unlikely, I accept not impossible, that there would be any because of the limited length of time that the policy was in force and the lack of success of it in the terms that well, firstly, there was a 10 case limit per week. But secondly, even those cases that went through the system and reached a second opinion, didn't reach a second opinion. So they, because of breach of the time limits imposed by the policy. So there will be...
Well, that particular point's a bad point, isn't it? Because clearly, if they went into the system, there would have been delay pending the report, although in the event the report never came.
It's a diminished point, not necessarily a bad point. Though there may have been some delay, depending at which stage the time limit was breached, how far down the line. So I accept
periods of time wouldn't be huge. They'd vary from case to case, and given the sort of level of lumbar damages, but it would be a claim worth bringing. Well,
yep.
You could get someone to pay for it. Yeah.
Yes, one can speculate.
Yes.
I mean, I'm not putting the case so high as to say that there isn't a prospect of claims.
Not very likely is what you put, and I see why.
But it's not an issue on which my clients have any interest. Then they wouldn't benefit from any claims.
That must be irrelevant, though, mustn't it? If the fact were that you having brought this case actually rendered it very likely that there were individual people out there, then it doesn't really matter whether your client would benefit.
Well,
though in another sense it would, because they are the kind of people whose interests your clients exist to protect.
My Lord, I accept that to this extent, is that it may bring into play the Lord Justice Popplewell indemnity as to whether if the Secretary of State wants to overturn this in order to protect herself against putative future claims, then it should be she who is paying for it.
That's a point which, if it becomes
we haven't got that.
The outcome, you can always make that point.
We haven't got that. Yeah. Final reference on the likelihood or otherwise of claims is the defendant's witnesses' evidence, page 196 of the supplementary bundle, which is where one gets the statistic that 80% of the referrals dropped out of the process. One doesn't know at what stage.
Yes, I saw that.
That's between July 22 and April 2023.
Okay. Right, so that's what you say on the damages point. What else?
That's what I say on the damages point. There are a variety of... Lord Justice Arnold had some reasons for refusing the application in July when it was capable of saving some significant time. On the basis, firstly, that it didn't affect the second ground, where we haven't pursued the argument in relation to the second ground. Secondly, that the appeal is academic, is inconsistent with the respondent's notice, where we're not pursuing the respondent's notice any longer. thirdly, that the respondent hasn't accepted that the new guidance is lawful, but that simply doesn't arise in our respectful submission. If the new guidance is certainly not unlawful on the basis that we have been resisting this appeal on, namely the inconsistency with the statutory guidance in place at the time. The Secretary of State's reasons, I've dealt with no application that isn't pursued. There's an argument that the Salem would block right of access to the court, but in our submission there is no right of access to the court to determine disputes that have become academic. I think there's a suggestion that Salem's inapplicable to state bodies who seek to pursue points that have become academic, and that can't be made out on any authority in our submission. It's then suggested that the ex parte Salem conditions are satisfied, and we say then are not, in that there is no list on ground one, which is truly academic, and it's not of any continuing public importance to determine whether the superseded policy was unlawful. And the spectre of damages claim point I have dealt with and hasn't been made out in the way that it would need to be made out by some specific indications of actual claims or potential claims. And for what it's worth, and our field of vision...
we have the point. You don't need to...
You've got the point.
Hammer it in. Yeah. Anything else?
They also say that there are wider constitutional and reputational implications.
Yes.
Which I would respectfully submit is overblown.
I don't quite know what it means. We didn't really allow Mr. Payne to address us on that, but whatever we encouraged him not to do. He can do it, but essentially it must mean something like it's a serious thing to say the Secretary of State's acted unlawfully, but
it happens all the time, yeah.
Happens from time to time. Yeah.
My Lords, I'm sorry, I've overrun.
Can I just ask, yes. Your academic point doesn't apply to the consultation ground, is that right?
Oh, no longer. We had originally suggested that it did.
Right.
And it seemed to us that there was on reflection.
But suppose you got a decision which was the judge was entitled to make this finding of fact, but on any view, and its common ground, the evidence below was appalling. The Secretary of State might get stuck with the finding that there's a duty to consult medical justice when it was really only in relation to the evidence that was there before the judge.
But it's entirely in the Secretary of State's hands to end the practice of consultation. So we may or may not have exercised a course of conduct which constitutes, that's sufficiently consistent to constitute a promise, but that's over. So, I mean, there's the factual position was on the specific evidence before the judge, can't be transmuted into a subsequent case.
We'd say it would be open to us if we thought it appropriate in any judgment to make the point that this was both fact-specific to this particular situation, but also evidence-specific.
Absolutely, it was evidence-specific. I mean, the Secretary of State made the decision, which maybe is one that she would regret, not to put in any evidence at all. So Mr. Payne is left with trying to pick holes in what was the uncontradicted evidence from Ms. Hanley.
Okay. Right, well, we better hear from Mr. Payne.
My Lord, yes.
Unless my Lords have any further questions.
Thank you very much.
Yes, Mr. Payne.
My Lord, can I just touch very quickly on the academic point?
Yeah.
Just three points. The reputational issue, you're quite right, my Lord. The reputational issue arises from a finding that the Secretary of State has acted unlawfully. The fact that on other occasions the Secretary of State is found to act unlawfully isn't relevant. It is the fact that any decision, that any department of the state has acted unlawfully is a very serious decision. I cannot imagine going into court when the Secretary has been held to have acted unlawfully and saying that's not a serious matter. I mean, the court would be very surprised if I said that. It's also being referred to, this judgment is being referred to and was referred to in the House of Lords Committee. It's referred to in the supplementary skeleton argument.
Yes, you did refer to that, but I wasn't quite clear where that got you. I mean, it was that, as a matter of history, that made you make the change. It's referred to in the House of Lords Committee, but so what?
Well, my lord, if you're going to have a description of the Secretary of State's conduct and how it was unlawful being considered by the House of Lords Committee, surely you can see that the inference, it's not unfair for the Secretary of State to want that inference corrected in terms of the unlawfulness. And if you look, I don't want to take up much, I haven't got much time, but just 2 points. One is that in terms of costs, the application was made in front of Lord Justice Arnold, and a capping order was made by reference to the risk of this being academic. And that was accepted. That wasn't contested by the Secretary of State. Two, I'd ask you to go back and look at Lord Justice Arnold's reasons, because ground 2 is not ground 2 being pursued by the respondents. It's actually ground 2, our ground 2, which relates to consultation. The third point in terms of damages is it's two minor points in terms of the potential for damages. Obviously, the time frame is 6 years within which to bring a claim for damages. We certainly do not have to establish that a claim has already been brought. And on the website says you need to take advice as to whether you have a claim for damages. Yeah. But I know it's a minor point but you cannot say, and you cannot proceed on the basis that because one hasn't been brought, there isn't a risk that it will be brought. Last point in terms of Zoo Life, most of the cases, Zoo Life, they are decisions taken before you have the substantive judgment. Yeah, it's either a permission or do we go on and consider something. Yeah, there isn't one that I'm aware of, or certainly even Rehune. Rehune is a Court of Appeal decision where there is an adverse judgment. But the adverse judgment isn't a critical judgment. It's you're not entitled to your £15 a week. In the meantime, he gets his £15 a week. And we say that's very different from an adverse judgment saying you've acted unlawfully.
You could say you'd acted unlawfully and not, but I'm sure that not getting your £15 a week is unlawful of you not to pay it. No, but my lord, the person who was pursuing the appeal was the claimant who hadn't been given his £15.
Who was supposed to give him the £15?
The appellant hadn't been given the £15. So there wasn't.
From whom?
From a government department. I can't remember which one. But there wasn't an adverse.
Making a bad point. The government department.
The government department won.
Yes, I see. Yeah. Okay, got that. Yeah.
So slightly better.
Sorry.
And then the last point in terms of Zoo Life is that what the judge said is, well, I'm going to go on and consider it. Yeah. But he said it's all obiter. So that doesn't really help in the sense that were you to find that the judgment below it was flawed in terms of the unlawfulness, and that was an obiter point, it wouldn't, you would have wasted your time in making that assessment, and it wouldn't actually provide the benefit which the Secretary might otherwise gain from that. So those are my points in relation to academic.
Yeah.
Now, going to ground 1, I am going to take you to a few documents, and I'll do it as quick as I can. So the point was made in terms of the fact that the statutory guidance was in fact about process. Can you quickly take up the statutory guidance, please? That's at page 289. And so, my lord, the simple point is, if you look at the opening sentence, it's the matters to be taken into account. That's what it says in paragraph 1. And the reference to process when you go through the policy is the process you apply when making the decision, not how you make the decision. It's when you make it. So when you're making the decision. So you go to the next page. It says principles. It then says you first of all look at whether someone's at risk. That's page 291. Then once you've done that, you look at the weight of evidence, and it goes on like that. So the process is when you make the decision, not how you make the decision. And that's why the SOP starts off by saying this is about the process, how you make the decision. And the other point, whilst you're on that page on 289, is because the entire focus of my learned friend's submission is about the presumption against thing. But if you in fact look at that paragraph 1, which I've taken you to, there are in fact a host of considerations. I mean, it's genuine. That's one of the points. It's the balance between immigration and individual. If you look at the last sentence, so yes, there's a presumption. I mean, obviously, but this is about getting that balance right. It's not about saying if there's any risk of or a risk of an adult risk, you have to take this decision and release. The third point I wish to make is that some of the examples that my learned that were put to my learned friend. So, level 1, for example, the self-declaration, and I think the answer to that was, well, the person's likely to be disbelieved, so he wouldn't be released. But that, with respect, it sort of does circumvent or miss really the point that's being made, which is, and the reality is, if there's a self-declaration, if you look at the AR, which I'm going to take you very quickly, it's perfectly permissible to ask the person who makes the self-declaration, well, put in some evidence, give us some information. So, in other words, not to take the decision until, or at least give the person an opportunity to provide that information. Then the point was made about level 3. Well, what happens if there's some,
It's true, isn't it? The self-declaration people are not inherently places where the risk is inherently less likely.
No. I mean, in theory, yeah.
It's a self-declaration, but it could be in relation to a very serious harm.
Yeah.
Yeah.
But the key point is you can ask them. If you,
yeah.
I'll take you to that very quickly. So if you just turn to supplemental bundle 215. 215. Oh, hang on. Yeah. Sorry, big one. That's a different point. So I'm trying to do it quickly. I've gone too fast. I might just due to time. I might have to leave that one.
You can come back to it if you like, and
yeah,
Xander can supply the reference in the meantime.
Yeah, I will come back to it because it does say that when it's a self-declaration, you need to effectively give them an opportunity to provide evidence and support.
Okay.
Level 3, there was a suggestion that, well, if the caseworker had some sort of reason to disbelieve the person, then you could sort of effectively reject or take a decision on that basis. But if you, and this is 215, if you look at what in fact the guidance says at the top paragraph, you can see that would be a decision extremely vulnerable to challenge.
Yep.
So the reality is, faced with a level 3, you've got to release on the claimant's case, and and once you've released, you've got all the absconding, which you've got. If it's a foreign national offender, you've got the additional risks, and that is precisely the balance which the statutory guidance seeks to deal with. And there's absolutely no suggestion in the statutory guidance that you actually need to take a decision before you're in a reasonable position to assess genuineness and the countervailing considerations. My next point is the word available, what it means. You made the point, my lord, but I would also just invite you to look at it when you're looking at the normal, ordinary meaning of available, certainly in the public law context, it's tame side. And if you're going to sort of depart from that, we would submit very, very clear wording. If you're going to exclude reasonable or material that could be reasonably...
Sorry, I don't want to slow you down, but what did you say? The normal meaning of available in public law terms is tame side.
What I'm trying to say is that when you consider whether a public authority has properly exercised its discretion, you would normally apply the tame side principles in the sense that have they properly informed themselves in terms of the decision they're making, and it would be you'd have to have a very clear framework which prevented that happening, then requires a sort of a decision.
Okay, I've got the point now. I thought you were saying that there was some reference in Tameside to the concept of availability.
No.
Okay, I've
Big
got
bad
Yep,
and next point is just this point. If you look at, I won't ask you to go back to it, but if you go back to the statutory guidance when you're doing a judgment and you look at paragraph 10, paragraph 10 is obtaining decisions, tribunal determinations. There's actually no suggestion that you have to release between the two, or you have to take your decision on the level before you've got the determination. But the simple reality is that it's absolutely, in terms of the AAR, it's absolutely routine for, certainly in terms of physical conditions, for the healthcare assessment, the healthcare professionals to be asked for their view. It's very routine for the individual to be asked for permission to access his records. All of those are inquiries that are made to assess medical evidence. And there's no reason why those inquiries, those options shouldn't be available to the Secretary of State under the SOP or the statutory guidance. So next point is that my learned friend ended up practically accepting that it reasonable as opposed to de minimis. We're looking at the judgment, not the way my learned friend sort of articulates the point. Judgment is very clear, it's de minimis. One point I want to take you to was 227 and Rule 35, and that is in the core bundle.
Sorry, I wasn't keeping up.
Sorry about that. It's in the supplemental bundle, sorry, 227.
Yep.
And if you look at 227, if you look at the second paragraph from the bottom, it makes the obligation quite clear as to what needs to happen. You're quite right, my lord, the MLR is sent within 1 day of receipt to the healthcare team under the SOP. And so here you have the obligation and the very short time frame clearly set out. So you do have effectively a level 3 consideration, albeit not by the caseworker, but you certainly have it by reference by a medical person who, if anything, is better placed to make the assessment. And there, my lord, actually, if you go back to 225, that's the passage I was looking for earlier in terms of my level 1 example. And if you look at the second paragraph from the top, in the last sentence, it says, individuals self-declaring should be advised that they may provide supporting information if it's available.
Did Rule 35 feature in the submissions below at all? Because there doesn't seem to be much reference.
My lord, can I just say my back? My lord, I'm told they did.
Yeah. Okay, thanks.
Well, my lord, if you look at paragraph 76 in the judgment, I think it's even if Rule 35 isn't referred to, I think from memory it's 76. There is a clear reference to effectively mandatory obligation for healthcare to consider.
I think it's 75, which Mr. McCulloch relied on to say that the judge had answered, saying there was no answer for the defendant.
My lord, but that's, I think it's 75. It should be. I thought that was the submission. Sorry, big on 66, my lord.
Sorry, what are we looking at? Paragraph 66?
It was just the submission made by the Secretary of State before.
But answered by the judge at 75,
Yeah.
which Mr. McCulloch said encompassed, therefore.
Well, and if you remember in my original submissions, I said that it appeared that in 75 and 76 the judge had misunderstood.
Yeah, well,
but that was a submission I made.
Okay.
Moving on to consultation.
yes.
We say that that weasel words weren't used
I regret that phrase. It was
it was a joke, and I shouldn't. Maybe I thought maybe I shouldn't, but then I just.
But you know what I mean. It is the formula used to conceal what is sometimes in practice.
I do know. Anyway, I shouldn't have made the joke. But we would say that that's not what our appeal is about. We would say that this appeal is a mixed law and fact appeal. And we say you have a pure evaluative cases where there's evidence and effective findings are made on it, and then the judgment is made by reference to the findings of fact. We say that this is different because what we are saying is that we're not challenging so much the judge's findings, we are challenging whether his consideration of those findings by reference to the test. So we are saying he didn't apply the third limb. I took you to, and I'll just make that good by reference to, hopefully, by reference to the submissions I made yesterday. If you go to 73, page 101. No, I'm sorry, I got that wrong. If you go to, it's 162, page 123.
Sorry, where page?
Page 123.
Yep.
And the point I made, my lord, in terms of the last sentence, and you weren't very impressed by, was I said, if you read that last sentence, he refers to sufficient consistency, then he refers to imply, but what he doesn't refer to is the need for it to be unambiguous and without relevant qualification. And although, my lord, it might have appeared a bit of a technical point, and you said, well, no, he's already set out the test in 159. This is why I say it's mixed factor law, because if the fact was absolutely clear that it was unambiguous and devoid of relevant qualification, then it might be just a technical bad point. But since our whole case is, well, actually the evidence doesn't really isn't sufficient to arrive at to reach that conclusion. What you don't have is a judge saying, well, actually it is devoid of relevant qualification. And I'm just going to turn to MP for 1 second on that point, if I may.
Yeah.
I have to confess that my concerns about not giving the right weekly law reports were pretty minor compared to not providing this case. But there we are.
You didn't know the Constitution.
No, but I was trying to work out, my lord, how you had picked on paragraph 32 in Bapio so quickly. And I thought, well, there must be, I thought even speed reading is a very impressive pickup. So, my lord, in terms of...
I might say, looking at paragraph 55 of MP, the cross-reference within that Bapio is actually wrong. I think it says quoted in paragraph 46. It seems to be quoted in paragraph 47.
Well, I wasn't going to try my luck, to be honest. I hadn't picked it up. But so my lord, just very quickly on this. Given that, my lord, that you've written the judgment, I'm going to want to make 3 points really. If you look at page, it doesn't need to be paginated. If you look at paragraph 49, and if paragraph 49 quotes the case of Heathrow Hub, and sorry, if you can look at paragraph 46, please, and then we'll go to 49. That quotes Davies, and the paragraph that's quoted it recognises it's more difficult for the appellants to elevate a practice into an assurance. And then the last sentence says, the result is the appellants need evidence that the practice was so unambiguous, so widespread, so well established, so well recognised, as to carry within it a commitment to a group of taxpayers, including themselves, for treatment in accordance with it. And then, if you turn to 48...
Yes, that's actually not about consultation, is it? is a legitimate expectation.
My lord, yes, but that's...
Yeah, okay.
Yep,
48.
No, fair enough. No, I said then paragraph 49 was the one I was going to ask you to go to. And then if you look at the top of the page after 49 starts, and there's a quote from the Court of Appeal. There's 3 lines cited at the top.
Yep.
And then if you look at 69 quoted, it says, don't disagree with it, but it mustn't be read out of context. And this is the emphasis, that it's not just a pattern. It's got to be something which is impliedly tantamount to a promise. And its practice must still give a representation clear and ambiguous and devoid of qualification. Then if you look at the bottom 75, and then very quickly...
Sorry to interrupt.
Yes, no, of course.
And I appreciate we're pressed for time. But so you equate legitimate expectation as part of a duty to consult as part of a legitimate expectation, same jurisprudential base.
My lord, absolutely.
Yeah.
And my lord, the important thing, and this is again something that didn't find favour with Lord Justice Underhill. The reason I'm saying this is when I said, well, actually, a lot of the examples were by reference to the court or in response to court decisions. You, my lord, say, well, what's the relevance of that? And the relevance of that, we say, is because what you're looking for here, effectively, voluntary acts by the Secretary of State that create effectively an assurance as to what's going to happen in the future. And we say acts which are effectively dictated by others, like in response to a judgment, they can't really amount to a promise as to what the Secretary of State's going to decide to do in the future.
No, but the cases weren't cases that said you must consult.
Well, one did.
That was a settlement.
Yes, yeah, but still, when you're looking at the reason for the consultation, it's by reference to a settlement. It's not sort of some pattern of behaviour which the Secretary of State sort of voluntarily are undertaking because it must be important that when you're looking at whether it's right to fix the Secretary of State with sort of having made a promise as to what's going to happen in the future, that you look at the reason for previous consultation. My lord, you might not be with me, well, you probably aren't with me on that point, but it is really because this is also about unfairness. And if you look at the point, and again, this is just about my point as to the absence, the importance of an absence of the word sort of unequivocal or devoid of qualification. If you look at 51, the argument that was run there was that actually was based on the absence of the word sufficiently settled. And that was the challenge to the judgment, to the judge below. And that's dealt with at paragraph 54.
54 of what?
We're on 54 of the judgment in MP. And you can see from that paragraph, it's always a bit risky saying what you can see when when the person who wrote it's there. But what we would say that you can see that the reference to, there was a lack of reference as well to the unequivocal. No, he does refer to the unequivocal practice. And I got it the wrong way around. But if you read that judgment that paragraph in slow time, the importance of the criteria, the clear criteria being set out and being applied as a sort of legal issue,
I mean,
is highlighted there.
That paragraph could be used against you as well, in the sense that what I was saying there was, be careful in attaching too much importance to the old word used by the judge.
Yep.
And here we do see the judge setting out what I think is accepted to be the correct legal test.
Yeah.
Can one really infer from the fact that he doesn't repeat the precise words later in the judgment that he wasn't applying the right?
No, but I think we would say it goes beyond that, because all he says is imply. That's what he says. And then when you look at the reasoning, which I can't go back over because I don't have time, and you read it together. So as I did say, if it was just like a pretty clear evidence in that word, we wouldn't perhaps have such a strong argument. But here, given the uncertainty about the evidence, you need clarity as to what it is about that evidence and why it's unequivocal. And that's not addressed. You've simply got a pattern, which is enough to imply. And that's my point. And that is, we would submit a legal issue, because if you, and again, my lord, I hope I haven't misunderstood the judgment, but if you look at paragraph 54, that deals with that issue as a legal issue. And then 55 goes on to deal with the approach as in terms of whether there's an evidential.
I mean, certainly if you apply the wrong legal test, that's a legal issue.
Yeah, so that's why I was just trying to deal with the suggestion that this was just simply an evidential point. We might be wrong, but it isn't. It is a legal point, because we're saying effectively the unequivocal point wasn't.
I think time is getting very short.
Yeah.
Is there anything else you feel you have to say?
Well, my lord, I could answer that question two ways.
Well,
No,
again,
no. Can I just quickly check?
yes, of course.
On the DSO point, yeah, one of the critical things which I tried to highlight on the DSO point was, if you remember, all the references to consultation. If you look at the email addresses where things were sent and everything, there is DSO consultation. That's the email address. So we would submit that's clear evidence of a different approach being taken in relation to DSOs. And that's taken from the statement. And the point, three points if I may, and then that's it. So the importance about...
One sentence each.
Okay. Right. Let me just sort out my sentence, sorry. The importance about focusing on the policy, which in relation to the type of policies in relation to which it is said the duty to consult arises, shouldn't be underestimated, and nor should the fact that at paragraph 160, what is relied on in order to, as the basis for the finding of legitimate expectation, what is relied on is a much wider range of policies. Yeah, and in relation to
we have your point.
Okay.
We're putting it to Mr.
No, fair enough. And then, so my second point was, well, I don't think it's a forensic point, but when you were when my lone friend was asked to explain bits of the statement, the sort of replies you got were you have to put a cold tower on your head, look at a range of considerations, that sort of thing, and that's precisely really what we would say troubled the judge, which is why he asked questions. Yeah, which is what indicative of the weakness and the lack of availability in the lack of adequate evidence. And the last point, there's one point I wanted to raise. Oh yes, my lord, this is just because I set the hair running. Remember yesterday I said, and I think this is more for you, my lord, in terms of just broader cases. Do you remember I said that regulations subject to negative resolution took effect prior to it? I just hand you a case because I'm not sure that I'm actually right on that, so I'm withdrawing the submission, but I'm, just in case, I don't want you going into another case thinking Mr. Payne's let me down.
No,
So I'm not sure that I'm wrong, but there's a case.
Well, it's very marginal to the issues in the case.
Yeah, but if you're interested, my lord, I've handed up the case of what's it called? Not MP, it's DM.
Yeah.
And it deals with it, but it deals with it in the context of immigration rules, whereas Erskine suggests a different approach in terms of statutory instruments.
Okay,
but that's just for your. My lord, thank you.
Thank you very much.
Can I just ask one question? Were you seeking to draw at the end of paragraph 162 a distinction by use of the word imply rather than promise? Or was that just me misnoting?
No, that's exactly it.
You were saying he uses imply rather than promise.
Yeah, very loose, exactly. Promise.
Yeah, sorry.
So he could have said apply unequivocally or whatever, but promise, it's just, we say that, that's not there.
Thank you. Sorry to
interrupt. No, well, no problem. I will thank you for your patience.
No, it's been, we haven't required any patience listening to either of you.
My Lord, could I hopefully not overstretch
No,
that?
we might be testing our patience.
One reference. Mr. Payne was asked whether Rule 35 was argued below. Obviously, neither he nor I were there. But the skeleton argument is at core bundle page 131. We don't see any reference to Rule 35 there. I don't know what happened to it already.
Right. Thank you both very much, and those behind you, I'm sure, have contributed very helpfully to the submissions, and certainly we're grateful for the work done overnight to produce the schedule of the points made by Ms. Hanley. We will be reserving our judgments, which will be circulated in draft to council in the usual way. They will, of course, be circulated on the basis most recently and authoritatively expounded in the Counsel General for Wales case, which I won't seek to summarise here, but the essential point is that circulation is only for limited purposes and should therefore only go to people who it needs to be shown to for those purposes, and any further circulation may involve a contempt of court. Thank you very much.
Thank you. Angus, my first case this year, I wasn't going to be